So thank you everyone for joining us. My name is Eric Sapp. I'm a staff attorney at Legal Services for Prisoners with Children. Legal Services for Prisoners with Children is a nonprofit organization that serves as a legal support center throughout the state of California. And we advocate for the rights of formerly incarcerated and currently incarcerated individuals and their families and communities. We are a human rights organization practicing in the domains of state law, constitutional law, administrative law, and you name it. I'm going to very briefly introduce our panelists, and then we'll get going. First, we're going to have Mr. Paul Briley, who is my colleague and Deputy Director of Legal Services for Prisoners with Children. He has worked extensively on voting rights, restoring voting rights, incarcerated persons and formerly incarcerated persons, as well as on fines and fees and a range of other issues in this area. After that, we'll hear from Professor Rebecca Zietlow from the University of Toledo School of Law, where she is distinguished university professor and the Fornoff Professor of Law and Values. She's the author of numerous publications, including a critically acclaimed about James Mitchell Ashley called The Forgotten Emancipator, which details the of a lot of the developments of the Reconstruction era in civil rights. After that, we'll hear from Professor James Gray Pope, who is an emeritus professor at Rutgers School of Law. He's also published widely in law journals and has also in the 70s was very active in the union movement, and his scholarship reflects that strong commitment to labor rights. And last but not least, we'll hear from Professor Adam Davidson, who is an assistant professor of law at the University of Chicago. He has an excellent forthcoming article in the Columbia Law Review about which we may hear hopefully a little bit today.
You the host of that meeting.
Mm-hmm. And I note that Professor Davidson was a clerk of Guido Calabresi of the Second Circuit, who happened to be my torts professor in the first year of law school. So we have that in common. So without further ado, I'll ask everyone who's not speaking to please keep your microphone on silent so that we don't have noise disruptions, and we'll have plenty of time for questions after each of the panelists present. So Paul, I give the microphone to you.
Thank you for that introduction, Eric. Let us look to the past, but let us also look to the future. In the words of Maya Angelou, I am bringing the gifts that my ancestor gave. I am the dream and the hope of the slave. For at this moment, I am the whole reason they have existed at all. And we are the recovery from the doctrine of discovery. 571 years ago, 1452, Pope Nicholas V authorized to reduce every Muslim, pagan, and non-believer to perpetual slavery. This facilitated the slave trade from West Africa. A new form of slavery transformed Africa, Europe, and the Americas. For the first time, people saw other human beings as commodities, things to be bought, sold, and exploited to make enormous profits. This system changed the world. The United States was created in this context, forged by slavery, as well as a radical new concept, freedom. Contrary to the belief of 1619, the first enslaved Africans known to have been brought to this land was in 1526 by the Spanish explorer Lucas Vasquez de Leon. The first slaves to exist in the English colonies were brought 93 years later to Virginia in 1619. In 1667, the General Assembly of Virginia passed an act declaring the baptism of slaves did not exempt them from bondage, opposite in nature to the doctrine of discovery. In 1669, Virginia passed an act regarding the casual killing of enslaved people. If any slave resists his master, by the extremity of the correction should chance to die, that his death shall not be accompanied by a felony. This is all too familiar when we watch an officer tell someone to stop resisting, and that tragically ends by taking their life, and they are allowed to continue work with no consequence or felony. Prior to 1680, indentured servitude was the method of choice employed by many planters. The shift from indentured servants to slave labor accelerated once the slave trade made African slaves available in large numbers. Planters saw the benefit of slavery as lifelong and as a status of birth, which satisfied a continuous labor supply. The Declaration of Independence does not mention slavery, but through its silence condones enslavement. The United States expanded to twice its size after the American Revolution, triggering the mass movement of people, voluntary and by force. Slave owners pushed tens of thousands of enslaved African Americans west into rich farmland. The combined result was an economic boom and human displacement. Josiah Priest was a pro-slavery advocate and popular 19th century American writer. His work has been selected by scholars as being culturally important and is part of the knowledge base of civilization as we know it. In 1851, he wrote a book titled The Bible's Defense of Slavery. His work was widely received as the guidelines for the time period. Within his writings, he states, the appointment of this Negro race of men to servitude and slavery was a judicial act of God. Racial unity between poor and wealthy whites was defined as the slave population grew, and racial distinctions became interwoven into the laws and social fabric of America. This is where we are presently. History is not in the past. In the present language of the 13th Amendment, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Allow slavery to exist in other forms. This slavery exception clause remains in the U.S. Constitution and 16 state constitutions, as well as the islands of Guam, Puerto Rico, and the Virgin Islands, all of which fall under the jurisdiction of the United States. Slavery did not end after the Civil War. The practice of forced prison labor and remnants of slavery are embedded throughout our country's system of incarceration today. Although no courts explicitly order forced labor at criminal sentencing, finding authority in the Constitution, it is standard practice to force incarcerated people to perform labor, often in dangerous conditions against their will. Incarcerated people work as electricians, carpenters, cooks, firefighters, and hold many other positions that help operate prisons. But for their labor, they are paid 8 cents to $1 per hour. Incarcerated people have long faced cruel treatment for any work absences, physical violence, solitary confinement, and disciplinary write-ups that result in longer prison terms. California is only one of 16 states that still allows legalized constitutional slavery. ACA 8, also known as the End Slavery in California Act, would allow Californians the opportunity to vote to amend Article 1, Section 6 of the state constitution to prohibit slavery and involuntary servitude without exception. This is why All of Us or None is organizing our chapters across the country, sponsoring legislation such as ACA 8 to amend the state and federal constitution to remove the clause that allows slavery, also known as involuntary servitude. Through our grassroots organizing, we are building a powerful political movement to win full restoration of our human and civil rights, and we welcome you to join our efforts. Thank you.
Thank you, Paul. Next up, we have Professor Zietlow.
Thank you so much, Eric, for inviting me to speak today. I'm really honored to be here and speaking with my fellow panelists. I'm going to talk a little bit about the history, or the Reconstruction era history of the abolition of involuntary servitude and its relevance for today. And I really want to make 4 points. First of all, that the 13th Amendment abolished not only slavery, but involuntary servitude. Second, that it established what I've called a positive right to free labor. Third, that promise was never realized, and Paul talked about some of this already, due to inadequate enforcement of the protection against involuntary servitude. And finally, that that continues up till today, both for workers and people who are incarcerated in this country. So Paul already read the language of the 13th Amendment. It abolishes slavery and involuntary servitude. There is an exceptions clause with the exception for punishment of the crime that I do not believe, and I'm pretty sure Jim's going to talk about this, actually authorizes involuntary servitude as punishment for a crime, nor does it authorize the enslavement of people for punishment of the crime. That the Reconstruction Congress had a very broad view of what it meant to be free of involuntary servitude, what I've called a positive right to free labor, the right to work for a living wage, free of undue coercion, and free from discrimination based on immutable characteristics, in particular, of course, race discrimination. That its roots were in the antebellum activism against slavery, but also on behalf of workers' rights. And that the positive right to free labor has been enforced by Congress with laws, including the Anti-Peonage Act, which prohibits the holding of workers in involuntary servitude. And I can go into more detail on that if in the Q&A, but I don't want to take up too much time with my talk. So I'm going to move on to my next point, which is that it was never realized, right? That promise was never realized. After the end of Reconstruction in the southern states, a system of slavery and everything but name developed, both through the convict leasing system, incarcerating and forcing people who were accused of very, very minor crimes, such as walking on the street without being at work, and forcing those people to work in conditions that were reminiscent of slavery because they could not afford to pay the fines that they were forced to pay. In addition, the sharecropping system and other similar labor practices where people worked on land that was owned by other people. In fact, many people, and this is primarily African-American people in the South, had land that they owned taken away from them. The only way they could work on that land was to pay money to the people that owned the land, and that they were never able to get away from that, right? So they basically were in peonage, to working in conditions of peonage, working in conditions of being forced to stay because they always owed money to the landowner. They were buying, the food. The only place that they could buy food were in stores where they were charged exorbitant prices. They would bring their crops in at the end of the year, and they would not have enough money to be able to actually leave the land. So that was a system of labor that continued to be the primary way that the Southern economy functioned, at least through the 1930s and early and 1940s. That during the New Deal, the labor movement used the argument that being forced to work without being in unions was involuntary servitude and amounted to slavery. That Congress enacted laws protecting the right to organize for workers, built in part enforcing that view, but that the workers that were left out of those protective laws, agricultural workers and domestic workers, were not coincidentally workers who were primarily workers of color, especially in the southern states. There was a campaign by the Department of Justice to try to enforce the Anti-Peonage Act for those workers, and to stop them, to end the system that I was talking about of sharecropping, peonage, and with some success in during that time. Uh, the civil rights movement made some advances that affected this. We've just celebrated the anniversary of the March on Washington this week. Always the news emphasizing Martin Luther King and his "I Have a Dream" speech and the protection against racial segregation. But of course, that march was about way more than that. It was about workers' empowerment, it was about economic rights, it was about the right to earn a living wage, and the right to work without discrimination on the basis of race. So this continuing that tradition of linking economic rights with racial justice rights. But notwithstanding the advances that were made during the 1960s in the civil rights movement, enacting civil rights legislation, aspects of involuntary servitude continue to today. So Paul was talking about the fact that incarcerated people are forced to work today. Corporations, for-profit prisons, forcing people who are imprisoned in those prisons to work. Is one example of involuntary servitude that continues to today. I've also written about other forms of involuntary servitude, including the use of undocumented workers on agricultural jobs. Undocumented workers were primarily workers of color who have very few rights because many of them, they don't have the legal right to be in the country. So it's very easy to exploit them, to underpay them, to force them to work in poor conditions because they don't really have any rights that they can enforce. In today's gig economy, we have a decrease of workers that are represented by unions that have the protection. Instead, we have workers that are increasingly vulnerable, ironically under the name of liberty, right? You can work a gig, you can work wherever you want. And that the actual reality of many workers is that they are they're working for companies such as Uber, other companies where they have to be certain places at certain times, where they have to earn a 5-star review, where they really lack control over their lives, and where they don't earn decent wages, they lack job security, and they do not get benefits from their job. So all of this is of a big concern to me, and I think an example of problems in our that could be addressed, I think, by enforcement of the involuntary servitude clause. And I'm really excited to see so many people here today that are working in this area, developing what it means to be free of involuntary servitude. And if anyone is interested, I've published a lot about everything that I talked about today, and I'd be very happy if you want more in-depth information to provide you with those publications. Thank you very much.
Thank you very much, Professor Zietlow. Next up, we have Professor Pope.
Hi, everybody, and thanks to Paul and Rebecca for giving us the big picture here. I'm going to zero in on the punishment exception to the 13th Amendment. And basically what I'm doing here, I've got this law review article. It's way too long. It's full of footnotes. It reflects really 4 or 5 years of total obsession with this topic. So I wouldn't advise inflicting it on the faint-hearted. But I've gone into this stuff, and I want to give you some of the main points that after all that digging into stuff I came out with. So I'm sure you're all aware that there's been a long time consensus view that once you're convicted of a crime, you can be subjected at least to involuntary servitude, and maybe even to outright slavery. People on all positions of the political spectrum have touted this as the gospel. The 13th Amendment authorized, according to this view, convict leasing and a lot of practices that go on today that are associated with mass incarceration. My thesis is that this is the view of ex-Confederate slave masters. It was embraced not because it was correct on the merits. In fact, it's, I think, quite clearly incorrect on the merits, but it was embraced because of power that the Democratic Party had in the South as the self-proclaimed white man's party following Reconstruction. So the positive thesis of my article is, if we apply the standard methods of constitutional interpretation to the 13th Amendment, then the punishment exception is much narrower. And in fact, the 13th Amendment, as Rebecca suggested, outlaws much of what's going on today in United States prisons, not only forced labor, but also arguably the subjection of people to prison conditions that amount to stripping them of basic protection against violence. This is a hallmark badge of slavery, and I do not believe that the punishment clause authorizes that any more than it authorizes forced labor. So the stakes of this interpretive issue are high, and I'm like Rebecca. I'm really happy to be here among people who are interested in this, and I think Paul's introduction really set the right tone for this. This is a weighty issue, and so many people in the United States today just aren't tuning in unless they have family members who are imprisoned or friends who are imprisoned. And this is just it's a huge problem. Now, there are efforts, as everyone here knows, to amend state constitutions and the United States Constitution to eliminate the punishment exception. And I totally support all that. I think that often an amendment campaign goes along well with a litigation and legislation campaign to accomplish the same objectives. That's what we saw with the expansion of equal protection jurisprudence to protect women's rights. The two went together. And even though the amendment never passed, the Equal Rights Amendment, many gains were made. Of course, they fell far short of what we wanted, but nevertheless, significant. Okay, so what I'm going to do with the remainder of my time is and I better figure out when it's going to end here. It's sad.
We're good on time.
Yeah,
We're
okay.
good on time. Yeah.
All right. So yeah, so you should feel free to just say, "Shut up, Pope." But I want to try to just get through the main points here. So, of course, the first thing is the text of the Constitution. And it positively amazes me to see how many courts and distinguished judges like Posner in the Eighth Circuit will say things like the 13th Amendment clearly authorizes the subjection of prisoners to slavery. Well, they don't say slavery usually, they say involuntary servitude. But this assertion that it's clear. But if we read the amendment literally, it's clear that this is not the case. So the 13th Amendment says neither slavery nor involuntary servitude shall exist. I'm pulling that from later on, except as a punishment for crime whereof the party shall have been duly convicted. So first of all, it can't exist except as a punishment for crime. Let's look at that part of it. If you read that literally, then neither slavery nor involuntary servitude can be inflicted for any purpose other than punishment. And yet much involuntary servitude in prisons today, and I would argue slavery in the form of subjecting people to stripping them of protection against violence and the threat of violence, for purposes like making, this is forced labor again, to make money for the state. That's a big purpose of forced prison labor. To provide cheap labor to private corporations. As Paul mentioned, prisoners work in all kinds of trades. They work for all kinds of employers. I mean, I go into some other ways in which prisoners generate profit nowadays. They generate profit in many ways, and that's not as punishment. That's as a source of exploitable labor. Also not to aid in prison discipline. Sometimes forced labor is imposed on prisons because it's supposedly good for prison discipline. That's not as a punishment. That's a wholly different policy. And most importantly, from my point of view, not to aid in rehabilitating prisoners, which is often a justification given. Now, you might think that involuntary servitude is warranted for those purposes as a matter of policy, but it's not as punishment, and therefore I would argue it is not constitutional. I just want to make one more point on rehabilitation of prisoners. Most prisoners want to work, as a lot of you know, I'm sure, if not everybody, but they want the work to be compensated and the conditions of employment to be fair. Back in the 20th century, California prisoners brought a lawsuit claiming that it was involuntary servitude not to be able to work in prison, that the deprivation of the opportunity to work constituted cruel and unusual punishment. But all that the amendment does is prohibit involuntary servitude. So all that's necessary to continue prison labor is to bring it above the standard of involuntary servitude. Okay, enough about the punishment only. And then it's supposed to be for crime whereof the party shall have been duly convicted. Well, if you read this literally, then forced labor cannot be imposed as a punishment for anything other than the particular crime for which the person was duly convicted. And how can you identify the punishment for a particular prisoner's crime? It's in the sentence. Duh. Look at any statute and it says the sentencing authority, the judge, or sometimes the jury, sentences the convicted person to a punishment. That is the punishment. And I think Paul mentioned this too in his introduction, that a lot of the people who are subjected to forced labor in prison today are subjected to that without it appearing in the sentence at all. And that's important because once it appears in the sentence that you're sentencing somebody to involuntary servitude, or worse yet, slavery, that kind of jars, I think, most Americans the wrong way. And I think that would, if you could just win on that right away increases the likelihood of winning on some of these issues. And I think Adam's going to probably talk a lot more about how to actually do that. Okay, so bottom line there, prison administrators are not empowered to decide to inflict involuntary servitude, much less slavery, because they don't have any authority to decide on the punishment for a crime of which somebody has been duly convicted. Only the judge or the jury have that authority. Okay, the next on our list of sources I'm figuring I've got about 5 minutes max here. Is original meaning. And of course, a lot of the current justices on the Supreme Court are big proponents of original meaning. That doesn't mean I think there's a chance in hell that most of them are going to look at a litigation challenge without a powerful political movement behind it and assess it in light of the merits. But I think that the merits, if we push them in many fora, and again, Adam's going to be talking about this, that's gonna be reinforced if we understand what the original meaning was. And I'm just going to mention a few things. First of all, there are plenty of on-point statements by leading Republican members of Congress, and keep in mind that at the time, the Republican Party was the party of freedom, the party of anti-slavery, and the Democrats were the party of slavery. The Republicans were the ones who pushed through the 13th Amendment. They're the ones who pushed through the early enforcement legislation, and they thought that the amendment prohibited involuntary servitude for any purpose other than punishment for the particular crime. And they thought that the contrary interpretation, that is the ex-Confederate interpretation, was narrow and absurd. So there are lots of quotations along these lines. I'm just going to give you my favorite one from Henry Deming, who was a conservative Republican from Connecticut. He says, "Southern states have ratified the amendment, but with a construction and gloss upon it, which is more trumpet-tongued proof of their perennial perfidy to the Black race than all the hypocritical mouthings of acquiescence in emancipation, which could be collected in a 6 months hunt from Richmond to the Rio Grande." And there are other statements, a little less passionate than that, but also indicating clearly that these Republican Congress people were interpreted the amendment in a way very different from that of the ex-Confederate slave masters, i.e., the position that prevails today. I could mention a lot of other quotations here. We don't have time. I also want to emphasize that there were system-level arguments at this time, and this fits in with what Rebecca said. Republicans and Democrats alike described the 13th Amendment as outlawing the system of slave labor and guaranteeing a, quote, system of free labor. And that was the meta principle that they used to distinguish violations of the amendment from practices that fell under the punishment exception and were therefore permissible. So some of the things that indicated that a given instance of forced labor, just to mention that at the moment, was did not fall within the punishment clause, were if you farmed out the convict to a private employer, that was pretty clearly in their view, that's not for punishment, that's to enrich the state and the private employer. Imposing servitude as a punishment for minor crimes. That you know, one thing that courts seem to have lost touch with totally is that slavery and involuntary servitude are next to death in the list of punishments. I mean, if you actually acknowledged that, if you required that legislatures specify them as punishments and put it in the sentencing, at least in the blue states, a lot of people would certainly balk at that. The people at the time, Republicans in Congress, thought of slavery and involuntary as horrific punishments that could only be imposed for major crime. And lots of other limits as well, based on this meta principle. Some of this was enacted in legislation. Of course, there were arguments on the other side, and I go into them in ad nauseum in this article with hundreds of footnotes if you're interested in why I think they're all full of shit. Sorry, pardon my French. All right, so precedent. I'm not going to go into that. There's no Supreme Court case on point. You can make lots of arguments on both sides. I do consider those arguments in the article. And lower courts, I think Adam's going to talk about that. The lower court decisions that authorize forced labor in prison are extremely weak. The main point I want to make about that is that they completely ignore the Republican interpretation and just uncritically embrace the ex-Confederate slave master interpretation of the amendment. So we get to mass incarceration. Mass incarceration has little to do with public protection. And a complication for those of us who believe that it's unconstitutional under the 13th Amendment, it's also not primarily a system of labor exploitation. Today, that's not the main thing. Convict leasing was designed to serve the needs of private corporations, including industrial corporations in the South after the Reconstruction era, and well, during it when they could get away with it. And today's system is not that. So it's a more complex argument, but I think the case is there that if you apply the Republican understanding of the amendment, many practices currently that are common under our regime of mass incarceration are unconstitutional. And finally, anybody who's litigating a case on this or, trying to develop a legislative challenge like Rebecca, I invite you to contact me. I'd love to talk with you about it. Thanks a lot for listening, and thanks to the group for organizing this panel.
Thank you very much, Professor Pope. Next up, Professor Davidson.
Okay, so I had some things prepared, but I see some stuff in the chat that I want to address because I think it kind of goes to the heart of what I was going to say. Okay, I guess I'll say by way of introduction, the way that I came to this, in addition to just sort of caring about the issue and the problem generally, is so I served as a federal law clerk for 3 years, a year in the district court, and then 2 years with appellate judges, including as Eric said, with Judge Calabrese, who until just a year ago taught torts at Yale for about 60 years. And the thing I realized is that despite seeing tens, if not hundreds of people sentenced and reading sentencing transcripts from all over the country, no one ever mentioned that either slavery or involuntary servitude was ever going to be a part of the punishments that were being imposed. It was not something that was litigated by prosecutors or public defenders, including very good public defenders and other defense attorneys. I clerked for some of the most liberal judges in the country. We didn't talk about it as we were considering what were at times very difficult sentencing issues. And the more I thought about that and the more I reflected on that, the more I wanted to figure out Professor Pope cursed, so I feel like he opened the door. What the hell is going on? This relates to sort of the discussions about the California Penal Code that are going on in the chat. Because what's going on is that everyone has been incredibly sloppy for, if not since the Civil War, certainly the last 60 plus years. And that includes legislatures at the state and federal level, that includes the courts. And I think there's a few reasons for this. The big reason is that post convict leasing, as the courts sort of struck that down through a variety of means and legislatures attacked it, the system that arose in its place that enables this the forced labor, the involuntary servitude, the slavery that occurs in prisons today. And I suppose I should say, just to reiterate what Professor Pope said, I'm going to talk a lot about forced labor, but that is certainly not the limit of what it seems the 13th Amendment does and should control. Slavery, including chattel enslavement, was not just about forced labor. It was about subjugation. It was about total subjugation by one to another. And so that's, I think, something important to keep in mind. But turning back to sort of how the courts and the legislatures have implemented forced labor, incarcerated forced labor, it's, as I said, never talked about before someone is convicted. And the vast majority of convictions, as I'm sure many of you know, occur through plea agreements, which means that there isn't a jury, there's not sort of usually litigation, it's usually public defender, but defense attorney advising their client about, well, here's what your punishment's going to be, here's what the prosecutor's offering, and here's what I think might happen at trial, that sort of thing. And obviously lots of other considerations come into that, things like immigration consequences, things like whether you're going to be incarcerated pre-trial, that go beyond just sort of guilt or innocence and trial outcomes. But it seems, and I've talked to a number of defense attorneys at this point about this, the possibility of involuntary servitude is never mentioned, and it's certainly never mentioned at sentencing by the judge, or when the judge takes the plea. And that sort of taking the plea is meant to be an outside check by the judiciary on whether the person who is pleading guilty to a crime understands the rights that they're giving up, as well as what their potential punishment might be. And so that's one thing that's going on. The thing that I believe Jesse brought up in the chat is the California Penal Code. And the California Penal Code does say in one section that all able-bodied prisoners shall be made to work. The interesting thing about this, and the interesting thing about the way this has been written into statutory codes across the country, is that language actually comes from a different part of the code from where you will find any other punishment. So the punishment for speeding, the punishment for manslaughter, whatever it may be, that will tell you, that will tell a judge, a defense attorney, a prosecutor, here's what the punishment is for this particular crime. That's not where you find that part of the code in basically any other part of, in basically anywhere in the country. What ends up happening is what I call in this paper that Eric alluded to, is what I call administrative enslavement. Basically, everything about involuntary servitude that occurs in prisons is handled by prison administrators, which have largely faced challenges to the breadth of the except clause, to the exception within the 13th Amendment, from pro se incarcerated litigants. They've been sloppy. They haven't issued well-reasoned opinions. They haven't taken these challenges seriously. And in part because of this, there are actually what I think are quite a few openings for people who do want to challenge this, who do want to challenge the continuation of slavery and involuntary servitude, particularly in the context of forced incarcerated labor. And you might think of those challenges as coming from a few directions. The first and most obvious one is, as Paul mentioned, is actually changing state constitutions. Changing the federal constitution would be amazing, but I think it is in part because a lot of these changes do happen through things like popular referenda, because people find out that, wait a second, we still have legalized slavery in our society and are appropriately horrified. You see a lot of these referenda passing with like 80%, 90% votes to alter state constitutions. And those kind of margins are just unheard of. So people are clearly troubled by this. Changing the federal constitution is just sort of a procedural nightmare. The fact that the ERA didn't pass, I think is a good example of the sorts of seemingly obvious changes we could make that are still, for a variety of reasons, incredibly difficult to make as changes to the federal constitution. But the other important point to emphasize is that the vast majority of incarceration of criminal law happens at the state level. And so by acting at the state level, you are in fact targeting the biggest source of this problem. But I also think that is unfortunately not going to be enough. Just like passing the 14th and 15th Amendments wasn't enough to ensure equality in our society, just changing the language of the Constitution isn't going to be enough, in no small part because there are a lot of people who are, for a variety of reasons, wedded to the status quo and who will work to uphold that. And so the other big ways I think this might be attacked are first legislatively, and in no small part, the way to attack this legislatively is, I think, not necessarily directly, that making a change to say all labor has to be voluntary might have an effect. But what I think is more likely to have an effect sort of on the ground for the lives of incarcerated people is to empower those people, whether by saying, if you work, you are entitled to similar protections as non-incarcerated people who work, or through things like changing the baseline of what someone can expect when they are incarcerated. So if the baseline for someone who's incarcerated is 24/7 solitary confinement, realistically, most people are going to choose to do almost any job if it means getting them out of that. And courts have said that, well, if you're choosing between the sort of normal conditions of confinement and work, that's a voluntary choice. And so it's not a 13th Amendment problem. It's not an involuntary servitude problem. And so you need to attack that before or in addition to just changing the language. And I think the last way, one of the other more promising ways to get at this problem is actually through prosecutors and defense attorneys. As I was saying, just shining a light on this problem existing for the legal profession is overwhelmingly liberal. For these nominally, at least, liberal people, is almost certainly going to force them to take a second look at their own actions and to start raising these challenges in the normal course of the criminal litigation that they are involved in. What I think that could create is a class of people who are convicted of crimes, but through the actions of defense attorneys, prosecutors, and judges who don't think that this is an appropriate punishment. As a result, convicted people who retain their full 13th Amendment rights, who are not subject to the exception. And that seems like an avenue that would force not only courts and legislators and lawyers to deal with the problem of the continuation of enslavement in our society, but would also force people in prison administration and imprisoned people to address it and empower imprisoned people to address it as well. These are all at the moment sort of very early stage ideas about how this sort of litigation and legislative campaigns and things might play out. Even as state constitutions have changed, there are examples from early lawsuits that suggest that the change on the ground hasn't been as gargantuan as you might think. And indeed, there are places across the country where there are statutes, where there are either longstanding longstanding constitutional language that doesn't include a sort of an exception, or statutes that say, well, all labor must be voluntary, where it seems like the reality on the ground for incarcerated people is basically the same as states that do have the exception. And so at the very early stages, I think there's a lot of possibilities, and I look forward to doing this work that I think could be very impactful for the lived experience of a lot of people.
Thank you very much, Professor Davidson. And again, we're very sorry for the interruption, but those were very thoughtful remarks. So before we kick it off to general Q&A, I have a few questions I want to ask to the panelists, and also give the panelists a chance to ask each other questions or make comments if they so choose. We're still trying behind the scenes to get Professor Pope back in here safely. So I have a question that's a textual question on the interpretation of the 13th Amendment. I understand that Professor Davidson reads the 13th Amendment such that the except clause modifies the scope both of the term slavery and that of involuntary servitude. Grammatically, that's certainly a possibility. That was also a grammatical possibility in the California state constitutions as they exist in 1849 and 1879. The current California Constitution divides those two provisions into separate sentences, period, and then involuntary servitude is prohibited except to punish crime. And so unlike the federal constitution and those state constitutions that are modeled similar to it or similar to the Northwest Ordinance, where the exception could govern either slavery or involuntary servitude, in California, it appears only to govern involuntary servitude. So I was wondering if you could go a little bit in, Professor Davidson or Professor Zietlow, if you have thoughts on that as to why you read the except clause as modifying the slavery provision as such.
Yeah, so I will say that I am as just sort of an abstract legal question, I'm kind of actually, and I've changed this in a Morton draft actually. I'm kind of agnostic on what the best reading of the full 13th Amendment and except clause is. But there are two things I would point out. The first is that one of the potentially stronger arguments that actually the except clause does modify slavery as well as involuntary servitude is exactly as you pointed out, that there are seemingly numerous states that have very clearly said slavery is banned entirely, involuntary servitude has this exception. But the broader point I would make is that it is wild that the courts haven't decided this question in the last 160 years. That if it is true that the correct, to the extent there is some, objectively correct reading of any law, reading of the 13th Amendment is that by being convicted of a crime, you can be enslaved, including, given our history, chattily enslaved. That seems like an enormous, devastating, horrific punishment. And that the federal courts across time, across however many hundreds of judges, have not said basically anything about this, I think is just another example of how this has been buried, not only to the public, but also to the legal profession as well.
And if I could add, if you look back at the original intent of the framers or the meaning of the 13th Amendment when it was adopted, which is the form of constitutional interpretation that the Supreme Court is using these days, right? What you find out is there's no effing way, excuse me, that the framers of the 13th Amendment were going to enact an amendment that was going to allow slavery. They wanted to abolish slavery, and they wanted to abolish involuntary servitude, which they made very clear by enacting the Anti-Peonage Act in 1867. They knew that the folks, the Southern, so there's a couple of things. First of all, they knew that the former slaveholders were going to try to reinstitute slavery, right? They knew that that was going to happen, and they did not. They thought that by enacting the 1866 Civil Rights Act, which also enforced the 13th Amendment, which prohibits race discrimination in contracts, they thought by doing that they were taking care of that problem. Maybe they were a little optimistic about that, right? The House of Representatives did pass a law that same year that would have said very clearly that slavery is not allowed as punishment for punishment of a crime. It did not pass in the Senate, in large part because the Senate was then focusing on the 14th Amendment and the 1866 Civil Rights Act. And again, saw that as a way to solve this problem. So one more thing, the language, they weren't careful about the language that they chose. They simply used the language from the Northwest Ordinance. There was a debate. The debate that they had about what language to use was whether it should focus on the abolition of slavery, or whether it should be a broader sort of equal rights amendment, which is what Charles Sumner wanted. That was the debate that they had. They chose the Northwest Ordinance in part because Thomas Jefferson wrote the Northwest Ordinance, and they were hoping to get some Democrats in the Reconstruction Congress to support the 13th Amendment. And he was their hero because he had been, he was a Democrat, or a Democratic Republican, as those of us who have watched Hamilton know. So all of that they're very, very strong reasons, very strong arguments. Again, as Jim said, just in addition, and just adding to Adam as well, if you don't mind, I haven't met you in person before, but I certainly hope I will soon. That it's just, this is a misinterpretation of the 13th Amendment, allowing, saying that the exceptions clause allows for the kind of practices that we see in prisons today.
And Professor Pope, welcome back to the room. We're glad to have you back. I want to ask a follow-up question to your talk. If you could say a little bit more about how convict leasing functioned, and why you think it's a categorically different phenomenon than the kinds of privatized prison labor that we see today.
Sure. In the post-war South, post-Civil War South, you had the biggest transfer of wealth in the history of this country from the slave masters to the formerly enslaved laborers. That was the largest single item of wealth in the South, so that the ex-Confederates, now former slave masters, now face the problem of how are they going to get a labor force, and they all ideologically believed that Black people could not be forced to work or would not work simply by the lure of wages. And in any case, they weren't interested in paying wages because they, as everybody here, I suspect, knows full well, they didn't really consider Black people to be people. So that they were living in a world where the whole concept of free labor simply could not apply to formerly enslaved people. So they needed some way to replace this enormous supply of lost labor. And convict leasing was the method they chose. You can find quotations from state legislators, mostly people in connection with state legislators, laying that out as a specific strategy, that they were going to use this exception to re-enslave people. And so that was the purpose. I don't think that the rise of mass incarceration resembles that at all. And in fact, as Bruce Western has written, the mass incarceration arose in a kind of reverse situation where the labor of Black people was not in demand, and there were huge numbers of unemployed people crammed by housing discrimination into limited spaces. And the point was to warehouse people, to get people off the street, and also it was there was a political reaction to the civil rights movement. In fact, this was also part of the original convict leasing. All these bogus crimes like pig laws and vagrancy laws and laws. I mean, Rebecca mentioned some of these at the beginning that penalized all kinds of behaviors that are petty behaviors. They were designed to force people to bow down. And I think that those two things to me seem to be what's responsible for mass incarceration. Certainly not crime, because crime was not rising. Crime was declining when the real push for mass incarceration came.
I just want to add really quickly, I think the convict leasing system also violated the 13th Amendment. It simply wasn't enforced. The federal government was not enforcing any reconstruction measures during the end of the 19th century and the beginning of the 20th century.
So I'm going to open the floor to questions. If anyone wants to raise their hand, I'll call on you, and you can also type your question into the chat and I can read that if you prefer to do it that way. Does anyone have any questions? I also have more questions if people don't speak up. Also, comments are perfectly welcome as well. So I'll ask another question since I don't see any hands yet. So let's assume that the 13th Amendment gets a pretty broad meaning of punishment, and there's no restriction from it on states' ability to compel labor from persons incarcerated pursuant to valid criminal convictions. Let's just assume that for the sake of argument. The reading of the 13th Amendment as a kind of authorizing statute, which one of the panelists said that Professor Posner had a reading where the 13th Amendment sort of authorizes imposition of slavery or involuntary servitude as a punishment for a crime. Seems to be quite dubious if you just substitute incarceration itself or fines for forced labor. No one would or few people would argue that the 13th Amendment places any prohibition on the ability to incarcerate someone or to impose fines, but at the same time, it doesn't itself authorize any incarceration or authorize any fines, because that has to be, done pursuant to a statute, pursuant to a criminal trial, pursuant to proper sentencing, and so forth and so on. So it's very curious that some courts or some judges tend to read it as an authorizing statute in that way. But I was wondering, could the panelists say a little bit more about whether other provisions of the Constitution impose limits on what can be done even under the 13th Amendment? Surely the First Amendment prevents a viewpoint-based enslavement, let's say. Can the 8th Amendment do some of the work that the 13th Amendment has not to this point done? Can the 5th Amendment or 14th Amendment's due process clauses impose significant limits on administrative enslavement, as Professor Davidson calls it? That's a question for any of the panelists.
I could give that a shot. The cruel and unusual punishment has been tried a lot. I would recommend Ahmed White's piece on, I'm blanking on the title of the piece, but American prisons, I think for anyone who's tuned in, are cruel and unusual punishment, do administer it in many ways. And as we know, the courts have gone the other way. So yes, but I would say yes, in terms of organizing a political movement, that also offers opportunities. I don't think that they're as powerful as the 13th Amendment, because the 13th Amendment, the evidence for the legal challenge, if you're talking about litigation, and you can litigate obviously state constitutional punishment exceptions, and that gets around the current Supreme Court majority. I would say that's more powerful. I would also, there's the due process clause, what goes on in prison. But that's, to me, they're less compelling. That's all.
I think the thing I would say, the 8th Amendment is, as Professor Pope said, is sort of the obvious potential check, but the courts have been incredibly dubious of 8th Amendment claims from incarcerated people for things that happen in prison that are basically anything other than the sort of like traditional modes of torture. So so there was an 8th Amendment case about tying someone to a hitching post in the middle of a hot day in the South, right? These sorts of things. Outside of that, the courts have been pretty dubious of those claims, wrongly in my view, but nevertheless. I think the due process clause going forward could be potentially more helpful. If we take the idea that this is supposed to be punishment seriously, there are a bunch of due process protections that are tied to the imposition of punishment in a criminal case. Some of those are embodied in statutory law, like the Federal Rules of Criminal Procedure. Others of those come through in things like the right to effective assistance of counsel, where the court has said that it's not just, how long are you going to be incarcerated? It's also sufficiently serious things like if there are going to be immigration consequences of your having a conviction. That your attorney has to inform you of those so that you can make an informed decision about whether or how you want to fight your criminal case. I saw a question for me in the chat that I'll very quickly get to about whether how forced labor appears in the California Penal Code in a different place than other punishments. So The question is sort of why is that and what's the history of it? My answer is I'm not actually quite sure. I think the reason for it, without having sort of interviewed the legislators who wrote this provision, is that, and I think this actually kind of goes back to your Eric point about it's weird to think of this language as this sort of authorizing statute. One thing that the courts have done with the 13th Amendment is they've basically allowed things that look like involuntary servitude. This includes, there's a case about being forced to work on the roads without pay, because it's something that has historically happened and was allowed under sort of the pre-13th Amendment common law because you're doing it in the public interest. And so I think the one argument for this sort of authorizing statute view is that what the courts are doing is they are preserving the pre-13th Amendment sort of common law status quo of, well, if you were incarcerated, often incarceration was tied to hard labor. And so what we have now isn't quite what hard labor used to be. It looks like something different. But I think that's one way that the authorizing statute interpretation has come about. But back to these state statutes. Part of the reason I don't know exactly why this has happened, but have a clue that the reason for it is how legislators have thought about prisons, and that they have not thought about this as a punishment. They've thought about this as, oh, well, this is just a thing that happens in prisons, and it's not of constitutional dimension, right? It's not of constitutional importance. And because of that, where you find all of these statutes that tell you about being forced to work when you are imprisoned is in all of the statutes that tell you about all of the other parts of prison administration, like hiring security guards and all of, how you run the building and all of these sorts of things. It's just, I think for these legislators, and this is not just California, but across the country, because this is a pattern that repeats itself. I think for these legislators, they just thought of, well, oh yeah, involuntary servitude, forced labor, that's just part of prison. And it's not something that we need to think about in the same way that we think about even the punishment for sort of low-level crime. Like I found one state where you can see what your punishment is going to be for speeding, but you're not going to see that you're going to be forced to labor once you're incarcerated.
So there's some discussion going on in the chat. One of the concepts that Dorsey Nunn raised in the chat is, how does human trafficking fit in to the 13th Amendment discussion? Is that another way of framing the issue that can be useful?
Yes, absolutely. And that's what Congress thought when they used relied on the 13th Amendment to amend and expand the meaning of the Human Trafficking Act in the 2000 Anti-Trafficking Act. So I think that is really also a statute. So I just want to take a step back and say, courts, as has been reflected in the discussion we're just having, courts have a tendency to very narrowly construe rights. And I actually think one of the good things about the 13th Amendment is the courts haven't done much interpretation of it, because they haven't taken its force away in the way they have, for example, the Equal Protection Clause, which now is only used right against laws, affirmative action laws that were designed to help people of color. So look at the statutes, look at the Anti-Peonage Act, look at the Anti-Trafficking Act. They are completely relevant and important and under-enforced. And I'm very sorry, but I need to leave. I just want to thank you very, very much again, everyone, for this panel and for the opportunity to speak to all of you. Thank you.
Thank you very much for your participation. was very educational. So one of the questions that was raised in the chat from Priya Kandaswamy asked Professor Davidson, quote, you mentioned that forced labor appears in the California penal code in a completely different place than other punishments. Can you say more about why that is and the history of that?
Yeah, so I think I'd just say briefly that I think the underlying reason for this is that legislatures just don't think of forcing incarcerated people to work as they don't connect it to the 13th Amendment. They don't connect it to this is constitutionally required to be a punishment. Instead, they just think of it as any other part of administering a prison. That it's the same as hiring requirements for prison guards, or sort of getting the land to build a prison. Any sort of administrative task that goes on that in the running of a prison, they view it in that way. Which is, I think indicative of the depth of the constitutional problem.
Henry, you have your hand up, and then followed by Sonia.
There's a common problem happening right now. We're pushing a lot of laws that are not honoring constitutional rights, and it's kind of like the youth offender bill for 18 to 25. The research now shows that they're considered to be youth because their brains don't fully develop, but yet they still sit in prison under life without parole. And the Hardin case took it before the judges, and even the judges acknowledged that, yeah, you know what, this is unconstitutionally not fit for, this law is not constitutionally fit for youth offenders, but it's a legislative issue. And it's like, how do we hold these legislators accountable legally, uplifting the Constitution and make sure that the legislative that's being pushed is honoring the constitutional rights of our people, or using it even to correct bills that are constitutionally not fit to honor our rights as human beings under this government.
Sonia, I think you're next on stack.
Thank you. Thank you so much to everyone for their presentation. I think I'm just trying to process how some of the things that you all have shared with us inform like legal political strategy today, being in California. Obviously, we have the movement around ACA 8 and our constitutional amendment, but I also feel like I've heard things like that won't be enough and that maybe we should look at litigation, but then the courts are so effed when it comes to interpretation of rights, so don't litigate it. So I guess if you all could boil it down, like, and maybe you don't have an opinion on this, but if you do, about like where you see some future fronts for activists trying to create a long-term political legal strategy around all the things that people are putting in the chat, in addition to eliminating slavery, but like all of the things that we see as slavery in our modern world, like how we feel that. I'm just curious if you all have advice or ideas or thoughts about legal political strategy that you would share with all of us on the ground.
I could say something about that. I think Adam might have something to say too, and maybe other people here as well. I'm not telling anybody here anything when I say, it takes a social movement to produce major change. And so I don't claim any special expertise at how social movements prevail. is more, but I can say something about the potential for using the Constitution, even though, as Henry says, it's the actual practice seems awfully far from the constitutional principle a lot of the time. And we're all familiar with examples of movements that use the Constitution effectively as a way to strengthen a political and a social movement. The civil rights movement of the 20th century, being a prime example. The women's rights movement, another example, less publicized. The labor movement of the earlier part of the 20th century. There are a number of things that the Constitution can do for people. One is, and I would say here that if there's interest in using the Constitution to deal with these problems, and I'm thinking especially of mass incarceration, but also trafficking, et cetera. And the first step is to decide then what provision of the Constitution, how are you going to proceed with this? And naturally, I'm advocating the 13th Amendment as a possible tool. And I know Rebecca does too, and I think Adam does. That's probably why we're here. With that said, I think litigation, moving for a constitutional amendment, but I see the Constitution having particular impact when people stand up and resist. So when prisoners go out on strike, in my view, it might enhance the power of their strike if they added a 13th Amendment claim, if they said they were striking against involuntary servitude, and that would then initially be treated as outrageous, just like the constitutional claims of other social movements at the beginning. But then it would gradually, that kind of thing would force more attention to the issue. So I think the Constitution has potential, the 13th Amendment in particular, and really it's, but it's a social and political movement, I would say, involved, and legislation as well. I mean, legislators can legislate to enforce the Constitution.
So I have a lot of thoughts, actually, Sonia, about your question. So I think the first thing I would say is I would be, while I agree that the courts are often, I'll just use the word fucked, in a variety of ways, I think it's important to be specific about which courts are especially fucked and which aren't. So the Supreme Court, actually, the Supreme Court I could actually see, particularly given the relatively strong, actually pretty, I think they're very strong originalist arguments for a narrower 13th Amendment, or excuse me, for a narrower interpretation of the except clause in the 13th Amendment. I think even the Supreme Court, given that there has been some pretty strong political movement on this front, might be pretty receptive to some arguments. But I think especially state courts where there has been constitutional change would be receptive, and there might be even more promise there. The other thing I would point out about the courts is that in basically every case that I cite in this like 30,000 word article, they are pro se. And I don't know if it's the same in the California state courts, but I can tell you that in every federal court I have been in, the treatment of pro se litigants is structurally different than the treatment of litigants who have attorneys. And what I mean by that is that those cases, the cases from pro se litigants, and often especially pro se incarcerated litigants, in no small part because of things like the Prison Litigation Reform Act, are put on different sort of fast tracks. There might be different clerks working on them, even if it's the same judges signing off. It's not the clerks in their chambers who are working on them. And so just by lawyers litigating this alongside incarcerated people, I think there's more promise in these sorts of claims than incarcerated people acting alone. And you actually see this in the cases. In the one case that happened in the Fifth Circuit of all places, down in, I believe it was Texas, where a court says, oh, wow, you are correct. It seems very strange to say that someone who was never told before their conviction was finalized that this would be part of their punishment can be forced to work. That seems wrong as a constitutional matter. That case was litigated by lawyers. That case, that person had some success, even if they didn't win on their 13th Amendment claim. And in fact, it was the only success across the federal courts, and it was so kind of seemingly outlandish once we were back to the status quo that the Fifth Circuit was like, oh no, we need to get rid of this, and overturns that case in a later one. And so I think just having lawyers litigating these cases might actually have a tangible effect on the outcomes. The other thing I would say is to take advantage of the places where progressive people, where liberal people, where leftist people have made inroads already. And so the places that come to mind immediately are defense attorneys, public defenders, and progressive prosecutors. I don't know what would happen if a prosecutor and defense attorney said, oh, we are going to negotiate as part of our plea agreement that part of the punishment here is not going to be the possibility of slavery or involuntary servitude. That punishment is not justified for whatever crime this person has committed. I don't know how I don't know how either the judiciary or prison administrators would respond, but I think that's an inroad, and I think that's an inroad that people could make could make while also working on the political backing and movement that they need to make the sort of lasting gains that I think we all want.
Kelly, you're next.
Thank you. Sorry, I couldn't find my video thing for a second. I actually have two questions. The first would be directed specifically to Professor Davidson. Maybe this is my cynicism talking, so bear with me. I heard you say that you would expect actual some positive results from our Supreme Court currently when it comes to the 13th Amendment, unless I misheard you. And I was curious if you could elaborate on that, because I immediately thought you were going to say that was one of the, pardon my language, fucked courts. And then my second question is that, as we know, there have been a couple of states now, more than a couple, that have amended their state constitution to remove the exception. And I'm just curious, and I apologize for the broadness of this question, but I'm just curious if you are, either of you are familiar or aware, or if anyone is, with the arguments that have been very successful in getting those exceptions removed.
I will very quickly address the one point of optimism I've maybe ever had about the Supreme Court. So I won't go into my whole theory of like how the court is acting, but I will say that one of the things it seems like they have been doing, especially post-Dobbs, is finding places where they can achieve seemingly liberal wins, sometimes, particularly when it seems like they think it's not going to have an enormous sort of impact on the politics of the things that they care about. And I think this might be a place, in no small part because the optics of this are play right into Justice Gorsuch's hero complex, right? Like Justice Gorsuch gets to write that, we have been insufficiently attentive to one of our most important constitutional amendments, and he gets to play the savior and all those sorts of things. And as Sonia alluded to, it's not clear how much just doing that is going to change the on the ground reality. And so I think that the court might be able to take that as one of their sort of moderating wins, while also believing that, well, unless a movement does come that they have to fight back against, that win isn't going to come at a huge cost to their sort of their on the ground ideals for imprisonment.
So there were two questions in the chat that deal with different aspects of the economics of incarcerated labor. Martha Winokur asks, is there a hidden agenda of making incarcerated people pay for their own incarceration? And we could say whether it's hidden or not. To what extent do the fiscal motives of compelling maintenance work inside prisons and jails play into the practices that we see? And then a question from Dr. Birch, quote, given that most imprisoned people want to work, would proposed constitutional reform primarily be about demanding better wages?
Eric, could you just restate the first one real quickly? Just
So the first question asked it asks if there's a hidden agenda, but it's even an explicit agenda of making persons incarcerated pay for their incarceration by performing maintenance work, especially while incarcerated.
Thank you. I would say that there's an unhidden agenda of in many states of getting prisoners to pay for their incarceration. There's a distinction between household chores, like you're not entitled in prison to have some domestic worker from the outside come in and clean your area and make your bed for you, etc. That's sort of one extreme of the spectrum. And then the other extreme of the spectrum is you're forced to work in a laundry for more than 12 hours a day, et cetera, under horrendous conditions. And then there's the overtly you have to pay thing, where people who have the money to pay for their incarceration costs just pay and they don't have to do any labor. In my view, that's the easy case. That's even though the courts don't agree on that at this point. And there's some great stuff by Noah Zatz on that. He's been really trying to lay the foundation for challenging that, because that's basically forcing somebody to work in order to pay off a debt. That is, you stay in prison until you've worked enough to pay off this obligation. And that seems to be clearly unconstitutional. It's just a question of the difficulty of getting that in front of judges who aren't, as Adam colorfully puts it, totally fucked. But then the other ones gets to be harder. What's the line? Certainly I would say that work in a prison laundry, that's where you get in. Somebody else had in the chat something about, yes, people are profiting. People profit from prisoners having to work in a laundry long hours. It's not just maintaining prisoners' clothes in a clean state. It's exploiting workers to enable either the state and or a private prison owner to make profit. So I would argue that's also unconstitutional.
Yeah, I would very quickly add, and this is admittedly, I think, just repeating what Professor Pope said. Yeah, there's nothing hidden about this agenda. It's in the statutes. I think at one point it was actually in Oregon State Constitution until it was very recently changed that imprisoned people were not working for themselves; they were working for the benefit of the state. And lots of statutes say that that is the intent of what is happening, is that the state is either saving money or in some cases just making money outright because of the forced labor of incarcerated people.
And briefly, Dr. Birch's comment about focusing on increased wages. Do our panelists have any thoughts about that?
Yeah, so I'll very briefly say, I think increased wages is certainly one part of it. I think we should think of less of a strong line between the things that build labor power outside of prisons and the things that build labor power inside, because wages certainly matter, but working conditions matter, hours matter, being able to choose your sort of professional choice and what kind of training you think you might be able to kind of training you might be able to use once you're not incarcerated again. All of these things interact to create the working environment, and they're not all substitutable with just increased wages. But I think I saw someone mention attic in here, people mentioned strikes. I think one of the other things that is important to make durable change is to empower incarcerated people themselves, because they're going to obviously have the most information about what's going on in their lives and what they need and what they want. And increased wages is certainly one way to, increase their economic power. But we also do need to be thinking about, what are the legal structures that we built that allow for non-incarcerated workers to have some power as well.
Geronimo, you're next.
Thank you, Eric, and thank you everyone for this very insightful panel. I serve as policy analyst for legal services for prisoners with children, helping lead some of our efforts on the legislative side, on the policy side with ACA 8. And so I first would like to make a quick pitch to recruit you all panelists that are here, and Dr. Rebecca as well, to help us craft our we're in the midst of crafting our language for this constitutional amendment here in California. We know how serious and important this issue is, and we're taking a lot of great care in making sure that we get the language right. We're going through it with a fine-tooth comb. When we first started this work, and a lot of us thought like we just have to cross out the exception, right? That's it, and we're done. But now we realize that it's much more comprehensive than that. And so we would love your support, or even just any type of insight, or if we could have open lines of communication, so you could take a look at maybe some of the language that we're thinking about introducing. We're, like I said, we're in the legislative process now, and we have until June 24th of next year to get this thing on the November ballot. So it is a crunch in time, but we would love your insight on that. And to the issue of wages as well, I just want to kind of ask if you think that this is kind of sound strategy in your estimation. What we have done is kind of separated out the issues between wages and kind of the constitutional rights that we're trying to gain through the Article 1, Section 6, which is like the 13th Amendment in the California Constitution. And so we've like had a campaign that's a separate legislation that's on wages to try to gain wages for incarcerated workers. That's actually included with hopefully raising the minimum wage for all Californians. And we have it separated out for a reason, because in the past we've seen the cost be brought up. So folks that might be sympathetic to the cause, like, oh, well, yeah, we think the Constitution needs to be changed, but it would cost California so much to pay people minimum wage and all that. And so we've separated out the issues. We think that they are different and distinct in their own right. Do you think, though, that there's like an order that these things need to be done in? Is it like, should we go after the constitutional right and then maybe follow up later with, you know, trying to get wages and other things? Can they be done simultaneously? Just some thoughts on some of that strategy. Thank you.
I could start on that. I think you're absolutely right to be separating the issues because it would be very hard to write a constitutional provision that governed wages that down the road you might not regret because it locks you in, and you might rather deal with ordinary legislative processes on that one. You know, this is Tina Chris on the chat. It looks like, yeah, she raised a really important point about, you know, what's voluntary, and once something's voluntary, the case she talks about, you know, the person who joins the firefighting option, you know, she voluntarily joins it according to her. And then all these horrific things turn out to be the norm on the job. Well, how do you deal with that? And that's a place where the language, it might be possible to craft language in the constitutional amendment that could deal with that a little, because it's, in my opinion, and this, you know, again, I mentioned this lawsuit by California prisoners claiming that it was cruel and unusual punishment not to have a work option. You need to be able to do some useful work while you're in prison. But on the other hand, if your options are doing nothing and sitting around facing possible threats of violence all the time versus doing something meaningful, or at least that puts you in contact with other people in a positive way, and fighting fires, of course, is also heroic on top of everything else, then you make that voluntary choice. Does that mean that any kind of servitude can be imposed on you? I don't see that voluntariness, that you can truly be making a fully voluntary decision to accept just any old labor standard when you're in prison, and the alternative is doing nothing. So I think that, you know, she raises a really important problem. I have made arguments that, in fact, that servitude is an equally important part of things, and that you shouldn't be subjected to servitude. You can work, but work doesn't have to be servitude. And so, you know, we could talk about that. That's a subtle point. And yeah, but I think you're absolutely right on the separation, and happy to talk with you anytime about it.
Yeah, I would just add, I'm also happy to talk, and I'm not a political scientist, so I'm not going to pretend to know the right policy choice here. I will say that, like, as a legal matter, the thing that that simplifying does is it gives it creates fewer avenues of legal attack, is my guess. Obviously I'd have that, you know, every time you talk to a lawyer, disclaimer, like, this is not legal advice. This is just generally talking about the law. All those sorts of things apply. But yeah, that, as Professor Pope said, my initial inclination is that that's also the right sort of strategic choice, as well as, you know, if you tried to, as Professor Pope said, trying to craft that language as a constitutional matter. There was one state that did something like that in the opposite direction, which was Oregon, and they basically passed what looked like a forced labor statute into their state constitution, and it operated basically like a statute. And it was recently overturned, which suggests to me that by creating something more complex, you're going to open yourself up not just to legal attacks, but to maybe different and more effective political attacks as well.
Henry, you had your hand up for a while. Did you still have a question?
As we close, because I know it's getting late, I just want to explore your mind and ideas of how we can address this on the federal level, right? Federal constitutional rights that have been violated, because if you really break down this whole system, it's set up to keep us in institutionalized enslavement, you know, from not just incarceration of over being sentenced, the same people of color, same categories, and the enslavement, the restitution they take from us, that the fact that we don't get wages, the fact that we don't have union rights or social security that's established only to be spit out after 20, 30, 40 years as elders, and barely getting like a disability check for $1,000. So like, I think that this is beyond inhumane as we know it, right? But like, you know, as we put a wider scope towards the future, how you know, I just want us to maybe go home with this thought. How can we argue this on the federal level in Washington now that Biden uplifted marijuana convictions from people, as I'm hearing nationally, and being that I work for one of the Sacramento chapters, we have about 30 national chapters. Like, you know, this long-term fight right here, I think if we address these issues, these constitutional violations of inhumane treatment on some of the most vulnerable communities that have been impacted by childhood trauma, to be treated that way for generations and create this problem at this point of crisis, I think needs to be addressed on a federal level. And if I hope that hopefully in the future we can figure out what that looks like. And if there's any guidance and support in that vision, please let us know where we can find it. Thank you. And thank you again. Thank you, Eric, for the legal team and everybody. I value these legal discussions because we do a lot of legal advocacy. And now that we're pushing so many laws, we're doing a lot of resentencing and finally bringing these lifers home that never thought they would ever make it back out here. And it's all thanks through the guidance of people like you all.
Well, we're at time, and I want to thank Professor Davidson and Professor Pope and Professor Zietlow, who was with us earlier. And I apologize to everyone for the technical difficulties that we had earlier, but I appreciate that. A lot of people were able to ride it out, and it was a great discussion. And we'll try to edit the recording to get rid of the disruption and maybe have a product that some of the people who had to leave can still benefit from the discussion that ensued. Thank you very much, everyone, and have a good night.